Hello landlords, it's Ernie, I'm back. And today we're talking about writs of possession and when do you get them and how do you use them? What can you do to finally recover possession from a tenant who has lost the right? We're talking all about that today. Let's get started. If you're a landlord or a property investor or a property manager and interested in watching videos that have to do with landlord-tenant law, subscribe to this channel. You'll find all sorts of videos from how to prepare a good lease, how to deliver a notice to vacate, and how to properly file an eviction in your jurisdiction. If that's something you're interested in, again, don't hesitate to subscribe. Also, if you like what you see, give us a like and share your comments with us below. Thanks. So a lot of landlords, especially new landlords, get a bit confused with the function of the courts and how the courts are used in order to recover possession from tenants who have lost the right to possession, either due to a violation of the lease or for non-payment of rent. And so it's confusing to some people, you know, exactly how the courts work and what the courts are willing to enforce and what they simply will not enforce. So I'm going to take you through all of the steps in kind of a basic run of how recovery of possession works. So ideally, you're dealing with a written lease. You can have an oral lease in the state of Texas, but again, it's not ideal for a number of reasons. The main one being you don't have well-defined terms when you have simply an oral agreement. It's hard to prove precisely what you agree to. At best, you have an exchange of some amount of money for possession of property, and that's pretty much as far as most courts are willing to go. You know, I've argued some cases on behalf of both tenants and landlords on a purely oral lease, and there really isn't much leeway that the court is willing to give you in terms of what you're able to prove was your oral agreement. So you have a written lease, and the rules and the terms are laid out so that it's very clear what the tenant can and can't do. Namely, you want your tenant to pay a very specific amount of rent on a very specific day in a specific way to a specific person. If your lease is vague on any of these matters, you really should get your lease checked out and possibly get a new one. But if the tenant fails to make payment as is required in the lease, you have the right to file for an eviction. However, things get a little tricky when it's a matter of whether or not a tenant has violated a non-rent basis for the lease. You know, can you immediately run to the courthouse? Can you ask for possession? Well, what you need to know is what your lease requires. There are some leases that require the landlord to give written notice to a tenant who has defaulted in some non-rent basis of the lease. If your lease requires some kind of notice from you to your tenant, make sure you've given that notice before you hand them a notice to vacate. This notice of default could essentially hamstring you in court if it was a requisite to you demanding possession from your tenant through a notice to vacate. So make sure your lease is very clear. Does your lease require you to send notice to a tenant who has violated the lease for some non-rent basis? If so, how long are you required to give them before they can fix the problem? Your lease may say 3 days or 7 days or 10 days or longer. You need to know precisely what your lease requires of a tenant who is in default for something other than payment of rent. If you're required to give them that notice, give them the notice, do it in writing, follow what your lease says in terms of the method of the delivery of that notice and essentially the substance of that notice. What kinds of things are they allowed to fix? For example, you may have a term that says if someone is found with an unauthorized pet, you agree to give them a 10-day notice to cure that problem. If you come up to your tenant and say, look, I know you have a dog, you didn't sign up for a dog, you didn't pay a pet deposit, and pets are not allowed. And so the tenant says, oh yeah, this was a stray that we came across, we're not intending to keep the dog, we're gonna take the dog to place X. Again, if your lease requires you to give written notice to them, then you need to do that, otherwise you can't simply enforce a provision of your lease that you yourself haven't complied with. So send the written notice. If during that cure period, the tenant in fact removes the animal from the property, then they are no longer in violation. And so if your lease requires you to send notice and requires you to give an opportunity to your tenant, you can't simply rush to the next step, which is the notice to vacate. Make sure if you're required to give a notice of default or notice to cure, that you do so in accordance with your lease. Next is the notice to vacate. Now, generally speaking, your lease could say a notice to vacate has to be 3 days, or it could be 2 days, it could be 1 day. But the rule of thumb in Texas is a 3-day notice to vacate. I know you can bargain for fewer days. You really shouldn't make it longer because most courts like predictability. And so because in most cases it's 3 days, I'd keep it at 3 days. If your lease allows you to do it for fewer, you're not hurting anybody to give 3 full days of notice. When you send your notice, it must be in writing. You cannot email or text a notice to vacate. You cannot call a tenant and give them notice to vacate exclusively over the phone. Well, let me say it this way. You can do all of that, but none of that is effective in the court. Don't expect the court to assist you when you've given improper notice to vacate. The Texas Property Code, Chapter 24.005, specifically says your notice has to be in writing. And so your notice to vacate must be an unequivocal demand for possession. In other words, you're saying, get out, I want the property back. While that may seem harsh, if you are wishy-washy in your notice, the court may throw it out because it doesn't function as a notice to vacate. For example, if you say, you are currently in default for non-payment of rent. If you fail to pay rent, I may seek judicial remedies against you. Well, now that sounds very official and it sounds like it invokes the power of the court. Unfortunately, if you fail to demand possession, in other words, you fail to say the words, get out, or you must vacate, or you have 3 days before you must vacate, to some degree, if you have not made a demand for possession, you haven't sent a notice to vacate. Now, let's say your lease doesn't require a cure period, and you've sent a notice to vacate, and the 3 days have come and gone. Can you simply go to the house and physically remove anyone or remove any of their property? No, you simply cannot. The notice to vacate is not your judicial remedy. The notice to vacate is simply one of the steps that's required by Texas law for you to recover property. If the tenant, after you've delivered a notice to vacate, remains on the property, it is only then that you are allowed to seek the assistance of the court by filing an eviction petition. Now, that eviction petition has to be filed in a court of competent jurisdiction. That's the Justice Court in the state of Texas. And the Justice Court that's specific to your property is the one that's located in the same precinct where the rental property is located. You will file your petition in the proper precinct and the court will set the matter for a trial. Let's say on the day of trial, you show up and you prove your case perfectly. You have a copy of your written lease. You're able to demonstrate the default, whether it's non-payment or some non-rent issue or a combination of both. And you're able to convince the court that you're entitled to possession. You're awarded that possession. Maybe you're awarded back rent. Maybe you're awarded attorney fees. And you get a judgment. Now, can you take that judgment and rush to the tenant and then physically remove them from the property? No. You're still not done for a couple of reasons. Number one, by law, all orders that come from the Justice Court are appealable. And because of that, an order from the Justice Court is simply not final while the tenant still has a right to appeal. Generally speaking, after a judgment, a tenant will have 5 full days to appeal a judgment. And those are calendar days. So if, for example, a judgment is handed down on a Thursday, then you count Friday, Saturday, Sunday, Monday, Tuesday. That should be the last day to appeal, is Tuesday. Now, the rules can be a little wishy-washy, and I'm not going to get into why. Sometimes the courts will give a 6th day, right? So maybe it otherwise could be Tuesday, but the court gives Wednesday as a final day for that appeal. Unfortunately, you have to wait until the court says you are eligible for a writ of possession. The judgment that the court signs should inform you of that date. In other words, the judgment itself should have language in it that informs you of the first available day that you can request your writ of possession. Now remember, that judgment is not final until the tenant's right to appeal has essentially lapsed. If the tenant appeals, then that judgment no longer exists, And even if you get to the date that's written in the judgment, you simply cannot obtain a writ of possession because the tenant has appealed. And that appeal will start a new process in a higher court. You'll be informed of that new court, the new case number, and the new trial date. Well, you'll have to essentially prove your entire case over in front of a new judge. But let's assume that, in fact, the case was not appealed, that you secured a judgment, and now you've reached the date when a writ of possession is available. And you go to the court and you pay the fee to obtain a writ of possession, and you are granted a writ of possession. In fact, they give you a copy of the writ of possession that is signed by the judge. Can you take that writ of possession, signed by the judge, and march right to your tenant and forcibly remove your tenant from the property at that time? No, you still cannot. In fact, you are not able to forcibly remove any person or property from the premises without the county's approval. So how is a writ of possession exercised? Well, the county, usually the constables, will come out based on this writ of possession signed by the court. And they will exercise the writ of possession in your favor. Generally speaking, they will leave a 24-hour notice posted on the door of the premises, warning the tenant that if they're still there when the constables return, they will be forcibly removed, not by the landlord, but by the county constables. Constables will then coordinate with you to set up a date and time when you and they will show up and exercise the writ of possession. Now, for those tenants who remain on the property on the day that the writ is exercised, unfortunately at that point, those people will be forcibly removed by the constables. In Harris County, the constables ask that you bring your own moving crew, if it's needed, to empty out the unit. Once the constables remove all of the people, your crew will go in and remove all of the property. In Harris County, all of that property is simply put on the curb and left for trash pickup. At that point, you can recover possession of your property, you can rekey your door, and the process is essentially over. Remember, just because you have a writ of possession, or just because you have a judgment, or just because you've sent a notice to vacate, you cannot enter the property or forcibly remove anybody as though you have hit finality in your eviction process. Wait for the county to do its part. Remember, your part has to come after you followed each of these steps. If you have any questions about the eviction process or how to recover possession of real property, don't hesitate to leave a question in the comments section below. If you're interested in setting up a consultation to speak with me personally, you'll see that my email address and my phone number are here. Feel free to reach out to us by phone or by text with your questions and with your interest to set up a consultation. As always, we are appreciative of those of you who watch and comment below with the things you're thinking about. What questions do you have about a writ of possession or recovering possession from your tenants? Let me know in the comments below. Also, if you're interested in additional videos, here's one on the screen that YouTube apparently thinks you might enjoy. There's also a picture of my face here. You can click there and subscribe if you haven't done that already. Give us a like if you enjoyed this video, but until next time, happy leasing.